My rejoinder submissions, very short, my lords. Serial number 21 in the rejoinder submissions. I've tried to keep it quite brief. I'm responding specifically to the submissions on same-sex parenting, my lords, and adoption rights of same-sex couples by the argued yesterday by the National Commission for the Protection of Child Rights. I don't do so on my personal opinion. I do so on behalf of the Delhi Commission for the Protection of Child Rights. I have also attached, unlike the state, multiple studies with strong methodology, as well as other constitutional court decisions, South Africa, Brazil, multiple other constitutional courts on the right of same-sex couples to adopt, to parent, to be treated as a family, and to be given an equal dignity, and not be reduced to the category of those people. My lords, if I may, my lords, this is serial number 21. Please, my lords. Now, my lords, page 2 of my written submissions is a statement of the Indian Psychiatric Society that consists of 7,000 psychiatrists all over this country. My Lady Justice Kohli has the submissions, my lady.
Looking, I don't see.
This is serial number 21, my lady.
Not there. A few minutes before. You've just mailed it.
Oh, this is a new one.
Your new one.
This is just rejoinder submission, my lord.
But you already have. You already gave one last night and see it.
It's the same rejoinder submission. It's
We'll share it. I have it.
very well.
Mailed it in the meantime. It's being down.
Lord Justice,
I've been compelled to learn all this.
There is one which is
working
volume
well for us.
15. There's a volume 15.
Oh,
no,
Rejoinder.
no, my lord. It's
It's a rejoinder submission.
yesterday a folder of all rejoinder submissions. Earlier
Then
yesterday.
you are
just now.
Oh, I see. I
Just
see.
now.
so the dump continues.
Yeah.
Reading and giving purpose of interpretation to legislation. Yes.
So,
Got it.
Yeah.
so my lord Justice Narasimha has it, my lord. Yes.
Yes, please go on.
Yes. So, my lords, page 2, the Indian Psychiatric Society, which consists of 7,000 psychiatrists or specialists. It's the largest society of mental health professionals in India. The society supported the decriminalization of homosexuality in 2018, and this is what they had to say in April 2023. LGBTQ individuals be treated like all citizens of the country.
It's not here. Wait. Mail it. Abhi kara?
Yes, para 2, my Lord Justice, but that LGBTQ citizens be treated like all citizens of the country, and once a citizen can enjoy all civil rights like education, employment, housing, income, government, military service, access to healthcare, property rights, marriage, adoption, survivorship benefits, to name a few. There is no evidence to indicate that individuals on the LGBTQA spectrum cannot partake any of the above. On the contrary, discrimination which prevents the above leads to mental health issues. And in their recommendation, it is also of utmost importance that the family, community, school, and society in general are sensitized to protect and promote the development of such a child and prevent stigma and discrimination at any cost. This is a child being raised by same-sex parents. Now, my lords, if I may, my lords, there were 4 principal thrusts. So I'm just going to very quickly, I'm acutely aware of the time, my lords. Very quickly, psychological impact of children being brought up in same-sex households, my lords. Now, there are over 50 countries in the world that allow same-sex couples to adopt. So that is more than the number of countries that allow same-sex marriage. Those lists of countries are in the compilation. I'm not going to belabor this here. The most important points is that the big meta studies that have been done over the last 20 years in countries that have allowed same-sex couples to adopt, to have children, the big meta studies by the American Psychological Association, by meta-studies in the Netherlands, in Brazil, in South Africa, and all of that is in the note, all make 3 points. One, that there is no adverse impact on same-sex couples having children and those children. Two, if anything, the lack of protection adversely impacts those children. And three, that human sexuality develops quite early. So if you do not ensure equality and a protection from discrimination, then young people who are LGBTQ will be, in fact, psychologically impacted. This is what all the studies indicate. They are cited from in the note. And I want to take my lords to page 5, if I may. The American Sociological Review, based on very concrete data, has come to these conclusions. The academic results, this is page 5, my lords, of children raised by same-sex parents from birth outperform children with heterosexual parents by 0.139 standard deviations on academic tests. Children raised by same-sex parents from birth are 4.8 percentage points more likely to graduate from high school than children with different sex parents. Support for this hypothesis that has given time-consuming and costly procedures for same-sex couples to obtain children, same-sex parents typically will likely have higher socioeconomic status and therefore better academic outcomes. So I don't want to premise this. I don't want to premise this, and I would hope that in future, when the state comes to argue for or against a case, that the state will locate its findings, its opinions, and form those opinions after talking to communities, after actually relying on studies that do exist for the last 3 decades now in the public domain. Finally, my lords, I want to just take my lords briefly to judgments by other constitutional courts in support of equal parenting rights for same-sex couples. This is page 6 of my written note, my lords. The first case, page 7, para 16. The National Coalition for Gay and Lesbian Equality versus the Minister of Home Affairs. 2000, the year is Constitutional Court of South Africa. My lords, I just want to read these paras because it sums up this conversation here between these two sides that happened 13 years ago in South Africa. It said the South African Constitutional Court says this: from a legal and constitutional point of view, procreative potential is not a defining characteristic of conjugal relationships. Such a view would be deeply demeaning to couples, whether married or not, who for whatever reason are incapable of procreating when they commence such a relationship or become so at any time. It is demeaning to adoptive parents to suggest that their family is any less a family and any less entitled to respect and concern than a family with procreated children. I would even hold it to be demeaning of a couple who voluntarily decide not to have children or sexual relations with one another, this being a decision entirely within their protected sphere of freedom and privacy. In second place, there is no rational connection between the exclusion of same-sex life partners from the benefits of their laws and the governmental interests sought to be achieved thereby, namely the protection of families and the family life of heterosexual spouses. No conceivable way, nor can I think of any.
Dr. Guruswamy,
Yes.
could we have a look at the judgments later?
Yes, my
Because
lord. So
we
these
have 15
judgments.
minutes left, so we'll hear the two others.
Very well, my lords. These judgments are all there. There are multiple constitutional courts, and the DCPCR has given a list, my lords, it's a wish list, but of just guidelines on sensitization and education of society and steps that the government can take. I'm deeply obliged.
Thank you, Dr. Guruswamy. Thank you. Now, who will, Mr. Kripal, you'll be arguing.
Acutely aware that I'm on a conveyor belt. And one thing a conveyor belt does when it is go around. So it just reminds me as to why we started with this case in the first place. The idea, Millets, was to try to be equal citizens in this country, to get the same rights that everyone else has as heterosexuals, homosexuals. And Millets, marriage is a vehicle to adopt and obtain that ideal. It is not merely marriage as a social institution that we want. The reason we want marriage is because it is a conglomeration of rights, as was said on the very first date, that the state gives to you. Now, either we can fight for each of those rights individually, or we can get them in one fell swoop by virtue of a declaration by an act. Now, I quite see the problem with the latter. that if we ask for everything, we might end up getting nothing. So the correct thing for us is to ask for a declaration, as my lords have said, in terms of constitutional sense, that you have a fundamental right to marry. Now, Millets, the moment there is a fundamental right to marry, it follows that any two people have a fundamental right to marry, subject to certain state interests being complied with, which include both heterosexual and a non-heterosexual couple. Thus far, no problem. This declaration can come. But Millet, declaration must have a certain consequence in as much as it must ameliorate or identify or meet with the problems with which we came to the court in the first place. Because the declaration in a vacuum saying that the Supreme Court hereby declares that any two people have a right to get married must in some way be formalized into the practical impact of any two people's day-to-day life. So that when two people say that, look, the Supreme Court has said, I have a right to get married to my partner and therefore give him a visa or open a bank account or get an insurance document, there must be some formal aspect or carrying out in the nitty-gritty details, howsoever little, of that larger constitutional declaration of precept. What I would submit, Millets, is Section 4 of the Special Marriage Act gives just such a precept. My lords will recognize a right under Section 4 of the Special Marriage Act, in which case not much violence is done to the act of to Section 4. The problem arises in terms of unworkability once that declaration has been given to all the other rights. And there, I would say, hold your hands. Because it becomes, SMA will not become unworkable for the heterosexual community. It carries on working, it does. There are aspects of the SMA which may become unworkable. But I would just remind my lords that slightly unworkable is better than nothing. And nothing is what we have just now. So if we get a declaration under Section 4, it means a lot to any member of a community to go and tell their parents that, look, I'm getting married. It means a lot to any member of the community to say that the Supreme Court of India has permitted me and I have officially gotten married. It is an official document, which, in my Lord the Chief Justice's formulation of the 5 concepts of what include marriage, which is the ability to exclude, the right to cohabitation, the right to procreation. It is very important to have societal recognition of that relationship. And two people will not get societal recognition of their relationship by an abstruse declaration of the law for any two people by the Supreme Court. It must be carried into practice in some manner. And therefore, Section 4, a simpliciter declaration that you fall within Section 4 will suffice. To the extent, and my lord will see Section 4, my lord just call us in, there is actually no violence to the language of the Act that we will have to do substantially. Notwithstanding anything contained in any law for the time being enforced relating to the solemnization of marriages, a marriage between any two persons, no problem, may be solemnized under this Act if at the time of the marriage, the following conditions are fulfilled, namely, neither party has a spouse living, neither party is incapable of giving valid consent to it in consequence of unsoundness of mind, though capable of giving valid consent, has been suffering from mental disorder, has been subject to recurring. The only problems are C and potentially D. C, that the male has completed the age of 21 years and the female the age of 18 years, and the parties are not within the degrees of prohibited relationships. These are the only 2 sections that will have to be tweaked. If there's a problem that stems from 21A, that is left to a future wisdom. At best, what will happen? That you will not get certain rights. We are not getting those rights today in any case. So what is the worry? How is it an unworkability argument? This is an argument saying that you cannot get everything, so I will give you nothing. That argument will not suffice. The other alternative, Millers, as can be suggested, is Section 15 and 16. There, Millers, these problems of age as well as degree of prohibited relationships don't come in. My lord will see Section 15. Because a marriage can be solemnized under the chapter 1 of the SMA, it can also be registered under Chapter 3, registration of marriages celebrated in other forms. Any marriage celebrated whether before or under the commencement of this Act, other than a marriage solemnized under the SMA 72 or under this Act may be registered. So we get married anywhere else, it can be registered under this chapter by a marriage officer in the territories to which this Act extends if the following conditions are fulfilled. The ceremony of marriage has been performed between the parties and they have been living together as husband and wife ever since. Just stop here for a moment. a ceremony of marriage has not been defined as to what it is. It could be anything. I could go and either in Jewish tradition or Parsi tradition, because there are different forms. The act does not say what is a ceremony of marriage. It can be anything. I can go and tell before a priest of my choice or anyone saying, I hereby take you as my spouse. That would fall within the definition of ceremony of marriage because there is no description here in the act. My choice of ceremony will not run afoul of the act. And have been living together as husband and wife. This village can be tweaked to the extent of spouse. And the words are living together as husband and wife implies that you are in a cohabiting relationship. That is the implication of this particular subsection. But more importantly, let's see clause B has neither party has at the time of registration more than one spouse living. C, neither party is an idiot or a lunatic. This language really needs to be updated. B, the parties have completed age of 21 years at the time of registration. So there, this problem of 18 and 21 does not apply because both parties have to be 21. So whoever it may be. E, and again, parties are not within the degrees of prohibited relationship. So this also is gender neutral. It will apply to a man and a woman. There is no problem whatsoever in a section 15 argument, provided that in the case of marriage celebrated before the commencement, condition shall be subject to any law, custom, or usage having the force of law governing each of them, which permits a marriage between the two. Since it doesn't, this will not apply to us because we are getting married in a ceremony.
Degree of prohibited relationship is unprohibited relationship. Opposite. Yeah.
The problem 16 is a simpliciter recognition of once you fulfill the conditions in 15, 16 will be registered upon receipt of an application signed by both the parties to the marriage for the registration of the marriage, again gender neutral. Under this chapter, marriage officer shall give public notice thereof in such manner as may be prescribed. And the procedure will follow. So this is a gender neutral way of allowing marriage to be recognized. And the third is a submission that Mr. Rodhi gave, which that you allow registration of marriage under section 18F of the Registration Act. Because the only two problems I see with that, the only problem I see with that, and I would commend either section 4 or section 15 route, because both can be followed without much tinkering. Because every other unworkability argument also affects an introduction of Article 31D in our Constitution. Because future parliaments will now become very clever and say, why should I bother with amending the Constitution to save a legislation? I will just make it so complicated that striking it down becomes unworkable, and it therefore has a constitutional protection. For instance, when the reservation is to be given, I will give 2% reservations to 30 scheduled castes and not to the 31st. And say, well, if you strike it down, there's no reservation for anyone. Out it goes. Well, this is just one example of a potentially unworkable act being struck down, being rendered immune from judicial review on the ground of unworkability. There is reason why no case has been cited before my lords where the word unworkability has been used as a defense to constitutional examination, because it is not a valid constitutional defense. It is a purely legislative act which they're seeking now somehow to get over a fundamental rights by legislative device. That's something that cannot be permitted. That's all I have to say.
Thank you, Mr.
And let's just, we have an affidavit of Mr. Rodhi wanted to circulate as to what kind of affidavit can be given in case the registration under section 18F of the Registration Act is to be done. It's in volume 24 of our submissions. Obliged, my lord.
Yes, Ms. Grover.
Please, my lord. My lord, since my petitioners fall into two different groups, my prayers also, one relates to Special Marriage Act, which has been extensively argued. I would only add one strand to that for my lord's consideration, which is the ratio of Dharani sugars. That statutes must be treated as always speaking. My lord, the Chief Justice has applied that very ratio in Miss X versus Principal Secretary Health to read the impugned rules under the MTP Act to recognize a single woman's right to abortion where it related specifically to marital status. So whether that ratio can be deployed here to recognize LGBT couples' marriage within Special Marriage Act. My lords, the other prayers in my petition which relate to those who do not wish to necessarily be married within the legal regime have not been countered or opposed either in the counter affidavits filed or in the oral submissions, which are three prayers. One, to recognize, give constitutional recognition to my right to form a chosen family, which has already found recognition in the atypical family that my lords have elucidated upon. Then, which are can also be non-conjugal in intimacies that persons may have who are queer and trans persons. The second is the right to nominate beyond guardian, blood relative, or family member and assign various rights. And again, a constitutional recognition to that. And the third, which Mr. Ramachandran has already mentioned, a protocol of protection from violence, both building upon Shakti Vahini and the Madras High Court order, but ensuring that that provides agency and autonomy to those who are being safeguarded and protected. My lords, just one last bit in terms of non-workability. Again, I think Mr. Ramachandran has mentioned, because there was a lot of concern expressed by the respondents, the experience of NALSA and the Transgender Act. Different high courts, whether on issues of domestic violence, sexual violence, reservations, have made it workable, and that is an ongoing process. I would only reiterate what has been said just now again, to say that these are vulnerable, high-risk populations, particularly when there are further marginalizations of class, caste, etc. Non-recognition and non-granting of certain rights will certainly increase the discrimination and violence. So it is an Article 21 issue also. I'm very grateful.
Thank you, Ms. Prabhu.
My lords,
Yes, Nandi.
my lords have my submissions in
Yes.
rejoinder dated 10th May. It's in the
Yes.
common compilation that was sent, I think, yesterday morning, my lords. My lord, there are three propositions. One, happily, has been dealt with by Mr. Kirpal, that Chapter 3 of the Special Marriage Act, Sections 15 to 18, require the registration of marriages celebrated in other forms, and that these are gender neutral and may come to our aid without any words whatsoever being read into the Special Marriage Act, my lords. My lords, Mr. Kirpal has very well taken you through the section, so I won't do that. I will only add that when the section says as husband and wife should have been living together since the celebration, Black's Law Dictionary, the Oxford English Dictionary, it all comes to our aid, and it says that as means like, similar to, of the same kind, in the same manner.